हेलो एवरीवन। तो लास्ट वीडियो में हमने देखा था फंडामेंटल राइट्स, जिसमें कि राइट टू इक्वालिटी, राइट टू फ्रीडम, राइट अगेंस्ट एक्सप्लॉयटेशन पढ़ लिया था। राइट टू इक्वालिटी आर्टिकल 14 to 18, राइट टू फ्रीडम आर्टिकल 19 to 22, right against exploitation is article 23 and 24. Next, today we will read about right to freedom of religion under article 25 to 28. So let's start with article 25. So article 25 provides right to an individual with respect to one's religion. This article is not absolute. This right is subject to the restriction imposed by state on the grounds of public order, health, morality. Okay, and this right is available to both citizen as well as non-citizen. Okay, so this article says that all persons are equally entitled to freedom of conscience. ये क्या है? So this is a inner freedom of a person to mold his relationship with God in whatever manner he or she likes. Next is right to profess. So this is a declaration of one's religion, belief, and faith openly and freely. इसके बाद आता है right to practice. Right to practice is a performance of religion, religious worship, rituals, ceremonies, and exhibition of beliefs and ideas. इसके बाद आता है right to propagate. It means to spread, transmission of one's religious belief to other. It does not include to convert another person to one's own religion. प्रोपागेट स्प्रेड करने का ये मतलब नहीं हुआ कि आप दूसरे पर्सन को अपने रिलीजन में कन्वर्ट कर सकते हैं. नाउ स्टेट इज परमिटेड टू रेगुलेट और restrict any economic, financial, political, or any other secular activity associated with religious practice. And state is permitted to provide social welfare and reform, or through open Hindu religious institution of public character to all classes and section of Hindus. Next article is Article 26. Article 26, every religious denomination or any of its section shall have the following rights. First is right to establish and maintain institution for religious and charitable purposes. Next is right to manage. पहले तो establish and maintain. Next is right to manage its own affairs in matters of religion. Right to own and acquire movable and immovable property. Right to administer such property in accordance with law. So, this Article 26 protects the collective freedom of a religion. But Article 25 guarantees the right of individual. Article 26 guarantees the right of religious denomination or their section. एक section को protect कर रहा है. But 25 एक individual की बात करता है. Okay. Article 26 is also not absolute and subject to same as 25 public order, morality and health. 25 में एक extra था public order, morality, health and other provision related to the fundamental rights. ये इसमें नहीं है Article 26 में. Supreme Court held that religious denomination must satisfy three conditions. First is it should be a collection of individuals who have a system of beliefs. Second, it should have a common organization. Third is it should be designated by a कोई एक नाम होना चाहिए distinctive name. So according to Article 26 कौन कौन से rights होंगे? Rights to establish and maintain institution for religious and charitable purpose. Second is right to manage its own affairs in matter of religious. Third is right to own and acquire in matters of religion. Next, right to administer such. So Article 26 में कौन कौन से rights आएंगे? Right to establish and maintain institution for religious and charitable purposes. Next is right to manage its own affairs in matters of religion. Right to own and acquire movable and immovable property. Next is right to administer such property in accordance with the law. Let's move to next article, that is Article 27. This article says that state should not spend public money collected by way of tax for promotion or maintenance of any particular religion. This article prohibits favoring or patronizing or supporting one religion over the other. This means taxes can be used for promotion or maintenance of all religions. This provision does only prohibits levy of a tax and not a fee, because the purpose of a fee is to control a secular administration of a religious institution and not to promote or maintain religion. Moving to next article, that is Article 28. This article says no religious instruction shall be provided in any educational institution wholly maintained out of state fund. Thus, Article 28 distinguishes four different types of educational institution. पहला है institution wholly maintained by state. Second is institution administered by state but established under trust. Third one is institution recognized by state. Fourth one is institution receiving aid from state. In first case, wholly maintained by state, a religious instruction is completely prohibited. In second case, religious instruction is permitted. And third and fourth case, religious instruction is permitted on voluntary basis. Next article is Article 29. So, this article provides that any section of a citizen in any part of the India having distinct language, script or culture of its own, then shall have the right to conserve the same. Okay. Article 29 में ही that no citizen shall be denied to admission in any educational institution maintained by a state or receiving aid out of the state fund on the ground of only religion, race, caste or language. So, ये जो first provision है, this protects the right of a group. Protects the right of a group. But this second provision protects the right of the citizen as a individual. किसी individual को protect कर रहा है. And this Article 29 grants protection for both religious as well as linguistic minorities. And Supreme Court held that the scope of this Article 29 is not necessarily restricted to the minorities only. It extends to minorities as well as majority. Next article is Article 30. This article grants rights to a minorities to establish and administer educational institution of their choice. पहला तो ये हो गया. Second हो गया क्या? That the compensation amount fixed by a state for the compulsory acquisition of any property of a minority educational institution shall not restrict or abrogate the right guaranteed to them. ये कब ऐड हुआ था? 44th Constitutional Amendment Act 1978 से, to protect the right of minorities. Third point is In granting aid, the state shall not discriminate against any educational institution managed by a minority. एंड आर्टिकल 30 जो है ये सिर्फ प्रोटेक्शन टू ओनली टू अ माइनॉरिटी. आर्टिकल 29 में क्या था, मेजोरिटी एंड माइनॉरिटी दोनों आ रहे थे इसमें, बट इन केस ऑफ आर्टिकल 30 दिस इज ओनली फॉर माइनॉरिटीज. And this article 30 also includes right of the minority to impart education to its children in its own language. So the minority educational institution जो है वो 3 types के होंगे. First, institution that seek recognition as well as aid from a state. Second, institution that seeks only recognitions, not aid from a state. Third is institution that neither seek recognition nor aid from a state. So the first and second type of institution are subject to a regulatory power of a state with regard to a syllabus, prescription, academic standards, discipline, sanitation, employment of teaching staffs, and so on. But third institution है that is free to administer their affairs but subject to operations of general law like contract law, labor law, industrial law, tax law. Okay. In the judgment of Secretary of Malankara Syrian Catholic College case 2006, Supreme Court summarized general principles relating to establishment and administration of the minority schools. First, the right of minorities to establish and administer educational institution of their choice comprises the to choose a governing body, to appoint teaching staff, to admit eligible students of their choice, and to use its properties and assets for the benefits of the institution. ये first point हो गया. Second है, this right article 30 is only to ensure the equality with the majority, not intended to place the minority in advantageous position and majority in relation to a majority. There is no reverse discrimination in favor of minorities. This right to administer and establish educational institution is not absolute. There can be a regulatory measures, there can be standards and maintenance, there can be checks on administration. जो भी unaided institutions होंगे will have the freedom to appoint teachers. Fifth one is extension of aid by state does not alter the nature and character of a educational institution. Article 29 and Article 30 is a cultural and educational rights. Next is Article 32. So Article 32 is right to constitutional remedies. So Dr. Ambedkar called this article a most important article of the Constitution. An article without the Constitution would be nullity. It is very soul of the Constitution and very heart of it. Article 32 is a basic feature of the Constitution. जो भी ऑर्डर या जजमेंट issued for enforcement of a right is called as a writ. In India, both Supreme Court and High Court can issue a writ for the enforcement of rights. So, under Article 32, Supreme Court can issue a writ, and Article 226, High Court can issue a writs. Supreme Court can issue a writs against a person or a government throughout the territory of India, whereas High Court can issue the writs against a person residing or against a government within its territorial jurisdiction only, and in case outside its territorial jurisdiction only if the cause of action arises within its territorial jurisdictions. So the writs issuing power of the Supreme Court in this case is wider than a High Court. Second point है, Supreme Court can issue a writs only for the enforcement of the fundamental rights, but High Court can issue the writs for enforcement of the rights including fundamental rights, statutory rights, or for any other purpose. That is enforcement of ordinary legal rights. So in this case, the writ jurisdiction of the Supreme Court is narrower than that of the High Court. Third point is Article 32, the remedy under Article 32 is itself a fundamental right. Hence, Supreme Court cannot refuse to exercise its writ jurisdiction. On the other hand, Article 226 is a discretionary power. Hence, High Court may refuse to exercise its writ jurisdiction. So, Supreme Court is called as a defender and guarantor of the fundamental rights. So, the High Court and Supreme Court can issue the writs habeas corpus, mandamus, prohibition, certiorari, and quo warranto. So first writ is habeas corpus, which means to have the body of. So it is the order issued by a court to a person who has detained another person to produce his body before it. The court then examines the cause and legality of detention. And if the legality of the detention is found illegal, then the person would be set free. This writ is a bulwark of a individual liberty against arbitrary detention. This writ can be issued against both public authorities as well as private individuals. But this writ cannot be issued where detention is lawful, the proceeding is for contempt of legislature or court, detention is by a competent court, or detention is outside the jurisdiction of the court. Next writ is mandamus. Mandamus इसका मीनिंग हुआ we command. So it is issued by a court to a public official, asking him or her to perform his/her official duties, which he or she failed or refused to perform. It can be issued against any public body, corporation, or inferior court, or tribunal, or government for the same purpose. But this writ cannot be issued against any private individual or a body to enforce a departmental instruction that does not possess a statutory force, when the duty is a discretionary and not mandatory. To enforce contractual obligation against President of India or a state governor, against the Chief Justice of a High Court. Next writ है prohibition. And fourth writ is certiorari. Prohibition means to forbid, and certiorari means to be certified or to be informed. ये दोनों prohibition and certiorari can be issued only against a judicial and quasi-judicial authority. And both are not available against administrative authority, legislative bodies, and private individual or bodies. So the prohibition issued by the higher court to a lower court or a tribunal to prevent the latter from exceeding its jurisdictions. This prohibition is issued before the final order is passed for stopping the further continuation of the proceeding. Stopping the further continuation. Prohibition directs the inactivity and mandamus directs the activity, directs the public official to perform his or her official duties which he or she fails or refuse to perform. सर्चुरारी में क्या होता है कि हायर कोर्ट issued to a lower court or a tribunal to quash the order passed by the lower court or tribunal in a case. It is issued on the grounds of excess of jurisdiction, excess or lack of jurisdictions. This certiorari is issued after the final order is passed for quashing the same, but this prohibition is issued before the final order has been passed for stopping the further continuation of the proceedings. Next tweet है, fifth one is quo warranto. Meaning by what authority or warrant. It issued by the court to inquire into the legality of the claim of a person to a public office. It can only be issued in case of substantive public office of a permanent character created by a constitution. It cannot be issued in case of the ministerial office or private office. तो यहाँ पे हमारा रिट्स ख़त्म होते हैं. कितने रिट्स पढ़े हमने? 5. फर्स्ट वन इज habeas corpus, second one is mandamus, third is prohibition, fourth one is certiorari, and fifth one is quo warranto. Writs issued by Supreme Court and High Court. Article 33. This article empowers the Parliament to restrict or abrogate the fundamental rights of the members of the armed forces, paramilitary forces, police forces, intelligence agencies, and analogous forces. The objective of this provision is to ensure a proper discharge of their duties. And maintenance discipline among them. The power to make laws under Article 33 is conferred only on a parliament. So parliament can make only laws, not state legislatures. Any such laws made by the parliament cannot be challenged in any court on the ground of the contravention of any of the fundamental rights. So accordingly, the parliament has enacted many acts that, for example, Army Act 1950, Navy Act 1950, Air Force Act 1950, and etc. The expression members of armed forces, it also covers the barbers, carpenters, mechanics, cooks, and chowkidars also. Next article is Article 34. Martial law and fundamental rights. This Article 34 provides for the restrictions on the fundamental rights while martial law is in force in any area or within the territory of India. This martial law is borrowed in India from a English common law. This martial law is not defined anywhere in the constitution. This article empowers the parliament to indemnify any government servant or any other person for any act done by him or her in connection with maintenance or restoration of the order in any area where martial law was in force. The act of indemnity by parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. This martial law is imposed under the extraordinary condition like war or rebellion, violence. This Article 35. This article's power to make laws to give effect in a specified to a certain specified fundamental rights vest only in parliament, not in the state legislature. क्यों? To ensure the uniformity throughout the India. So the parliament shall have power to make laws with respect to the following: prescribing residence as a condition for certain employment, appointment in state, union territory और local authority. कौन से आर्टिकल में ये रेसिडेंस? आर्टिकल 16 में जो रेसिडेंस वन ऑफ द कंडीशन है, उसको रेसिडेंस को प्रिस्क्राइब करने का पावर किसके पास है? पावर पार्लियामेंट के पास. Parliament make laws with respect to empowering the courts other than the Supreme Court and the High Court to issue direction, order, and writs of all kinds. Parliament restricting, abrogating the application of fundamental rights to member of armed forces, police forces, and etc. Parliament indemnifying any government servant or any other person for act done during the operation of the martial law. Parliament shall have power to make laws for prescribing a punishment for those that acts are declared offense under fundamental rights. This includes untouchability under Article 17, traffic in human beings, and forced labor under Article 23. Third is any law in force at the commencement of the Constitution with respect any of the matters specified above is to continue force until altered or repealed or amended by a parliament. Okay, तो हमारा यहाँ पे टॉपिक खत्म होता है. Let's end here. Thank you.